Okay, I think we will resume with panel 2. I am Trina Jones again, a professor of law here at Duke University. I'm moderating this panel because my work focuses on employment discrimination with a particular focus on colorism and benefits to low-wage workers. I'm delighted to introduce our presenters this morning, and I'll start with Professor Ifeoma Ajunwa, who is the Asa Griggs Candler Professor of Law, the founding director of the AI and the Future of Work program, and the Associate Dean for Projects and Partnerships at Emory University School of Law. Her research interests lie at the intersection of law and technology, with a particular focus on ethical governance, privacy, and discrimination issues associated with workplace AI and automated decision-making techniques. Ifeoma has published both law review and peer review articles in leading journals. She is the author of the highly acclaimed book, The Quantified Worker, published by Cambridge University Press. And I went upstairs to get my copy so that I'd have a visual, but it's at home because I spend just about every day with this book. It's wonderful. She has a second book, The Oxford Handbook on Algorithmic Governance and the Law, which is forthcoming this year. She's an engaged public intellectual with an extensive list of bylines. She's testified before Congress, the Equal Employment Opportunity Commission, and has also spoken before the Consumer Financial Protection Board. She's a founding board member of the Labor Tech Research Network, which is an international group of scholars committed to the research of the ethics of AI use in the workplace and for labor. I could go on and on with each of our presenters, but I'm going to try to keep these bios fairly short. Paul Grantham, with each of the panels, we've tried to make sure that not only do we have scholars, but that we also have people who are working in the trenches and engaging with these issues every day. And so Paul is our representative in that dimension, who graciously agreed to join the panel this morning. He is an assistant vice president for work culture and communication services in Duke's Human Resource Department. He oversees the Office of Communication Services, which provides support for central administrative units and produces the Working at Duke print and digital channels. He's also responsible for supporting programs that promote a positive work culture and sense of belonging within the university. In that role, he develops affinity groups within the university and mentor programs for new managers. He also assesses data and workplace trends to develop strategies that support changing workplace dynamics. And then last but certainly not least is Professor Pauline Kim, who is the Daniel Noyes Kirby Professor of Law at Washington University School of Law. A renowned expert on the law governing the workplace, she has published dozens of articles and book chapters on issues affecting workers, such as privacy, discrimination, and job security. She's also co-authored one of the leading textbooks on employment law, work law, cases and materials. She's done foundational research on workers' understanding of their legal rights and on the risk of discrimination and unfairness posed by the use of automated decision systems and artificial intelligence in the workplace. Her current research centers on the legal and policy challenges raised when AI is used to make consequential decisions in employment, housing, and credit markets. She currently directs, you're busy, you're all busy, the Washington University Center for Empirical Research in the Law. She's a member of the Labor Law Group and has served as an advisor to the American Law Institute's restatement on employment law. In 2024, she was elected to the American Academy of Arts and Sciences and will be leaving us today early to go and accept that prestigious award. Congratulations, Pauline. So we're going to start with a series of questions before we open the floor to questions from all of you. According to Charlotte Burrows, who is the chairperson of the EEOC, the Equal Employment Opportunity Commission, 83% of U.S. employers and 99% of Fortune 500 companies use some form of automated tools to screen or rank applicants for hires. This is a large number of employers. I'll start with you, Ifeoma. How pervasive, well, I've talked about how pervasive the use of AI is. What are employers using AI for? And could you give us some examples just to set the stage?
Right. Yeah. So as you rightly note, AI technologies in hiring are quite pervasive. And in fact, it crosses all different sectors of work, different fields of work. And when it comes to hiring, the automated tools can range in sophistication and also in terms of the level of automation. So you can have simple tools that are used to parse resumes. So they just essentially will, divide resumes into categories for the human reviewer that will then look at those categories. But then you can also have tools so sophisticated that they actually are grading interviews. So you have this is called automated video interviewing, where the applicant actually is speaking into a camera, and that camera is creating a recording that will then actually be analyzed with AI to grade everything from the veracity of what the applicants is saying, their body language being used to determine also, more sort of abstract concepts like trustworthiness or conscientiousness and things like that.
Thank you.
Yeah.
So I'm always skeptical about new technologies. That's just my nature, unlike Rawa, who I think tends to be a little bit more optimistic. So there's a nice balance represented here today. So I want to start with you, Paul, in discussing some of the potential benefits, right, just to counter my skepticism, of AI for marginalized workers. And by marginalized workers, I mean people of color, women, people who have a fluid gender identity, and low-wage workers. So what are some of the potential benefits here? Some people have argued that these more neutral systems can produce less bias.
I think AI certainly offers a host of efficiencies, especially at broad scales, and that's something that we're excited about. We're also optimistically cautious about as well. But one of the biggest areas I think which has already been mentioned on the earlier panel is the potential to identify and mitigate bias. In the employment process and the recruiting process. Human resources operates at multiple levels, and so you have the corporate level where you make policies and affect kind of what the guidelines should be. But then you have the local level where your hiring manager is involved in making some of those decisions, right? And so we have countless thousands of hiring managers across Duke making decisions every day regarding employment. The other thing that we know, as was mentioned this morning, is humans are subject to bias, right? Some of you may be familiar with a study that was done about 20 years ago where some professors and researchers from MIT and University of Chicago took resumes and same resumes and put different names on them. So they put white-sounding names on them, or they put black-sounding names on them, and then they sent these resumes out to real applications that were out in the market. And the results were really stunning. So, the white-sounding names got 50% more callbacks than the black-sounding names. That survey, that study has been redone more recently this year. The results were, slightly better, from 9 to 24%. But still, it just reflects the bias that potentially is there in terms of at the local level. So, from a human resources perspective, like the potential of having a automated system take things like names out of consideration for that filtering process and say, we only want to look at the criteria that are specific to this job. I think that is where, we can at least reduce some of the potential hurdles to get through the system, to get into the employment process in ways that right now we know and suspect that that's not happening in the ways that we would want it to. So that is certainly one of the biggest areas in terms of benefits and helping to increase the opportunities for marginalized individuals. So the other thing, when I think about Duke, so we had in the last year we had 181,000 applications for people to work at this university. That resulted in about 3,600 actual people hired, right? We also know that the average hiring manager, this is not Duke specific, but the average hiring manager spends about 6 to 7 seconds in looking at a resume before they determine whether to move forward in the application process, right? So, if you think back to the cognitive biases that we all hold, how much in that 6 to 7 seconds are we actually engaging the prefrontal cortex in thinking deeply about the potential of this applicant moving forward versus making associations and biases in terms of that decision? So I think that the opportunity is huge in terms of helping to reduce potential bias in that process. And so, we have not moved forward here at Duke in terms of taking some of these systems from an enterprise basis. There's lots of use both at the local as well as kind of like the research basis, but in terms of big systems like SAP and Oracle and how do we apply that on a broad scale, the liability is still fairly significant and lots of questions to be asked before we move forward. There's an interesting thing happening over at University of Michigan. So they
Go blue. Different type of blue.
Yes, speaking of
Says the Michigan alum. And I think there was another person in the room.
I did not do this. I did not know. But so maize and blue, Michigan's colors. So they developed an app called Maisie, right? And so they use this app in various ways. But one of the ways I found interesting is that they had Maisie serve as the fourth member of a search committee in an interview process. And so they carried that process through, much like you were talking about, Fema, and around assessing each candidate coming through the process. The pilot they did, the AI, Maisie came back with the exact same results as the other 3 members of the search committee. But I can see this down the road potentially being used as a way to create efficiencies if we can confirm that we're not introducing bias, we're actually reducing bias. So.
Thank you, Paul. That's very helpful. And you can couple that with what we learned from the last panel about creating opportunities for creatives, right, in the entertainment industry with this technology, right, access to sources and so on and so forth. But then there's the downside, right? And Pauline, I'd like to come to you to talk about some potential downsides. In 2018, Amazon, so you talked about the resume study, which has gotten a lot of publicity, especially in the employment realm. But even if you remove the names, there's still the potential for bias. So in 2018, Amazon stopped using an AI hiring algorithm because the algorithm discriminated against women applying for tech jobs. After being trained on a data set that consisted mostly of men, the tool preferred applicants who use words that are more commonly used by men in their resumes, words like execute or capture. Among other words, right? So even if you're not looking at names, right, you don't have people looking at names, the technology, if it's trained on a particular data set, can produce certain gendered or race outcomes. So could you talk about some of the potential limitations of AI in the workplace?
Yeah, so I think that's absolutely right. AI, I think one of the risks with AI is that it's math, it's computers, people tend to assume that it's neutral and objective, but it's just a tool that has been created by humans, and depending on how they built it, what data they use, what the assumptions that were made in building the tool, it can incorporate prior biases, right? The other thing about a lot of these AI systems is they're often built looking at past data, so looking at past patterns and then trying to predict outcomes based on those past patterns. If you're working in an area like employment where in some sectors there's occupational segregation by race or by gender, and you're not paying attention to how you are creating the prediction task for the AI, you may be setting up a situation where all you're doing is asking the AI to replicate what already exists in the world, which may not be what we really are aspiring to in terms of the workforce. So I think there are a number of different ways in which these systems can either incorporate or reinforce existing biases. The other thing Ifeoma was kind of modest, I think, about her work that she's done. The book that was mentioned, Quantified Workers, is incredible. And she talks in that book not only about screening tools, but about algorithmic management tools that are used sort of so far we've been talking about screening access to employment at the outset, but she documents a whole slate of ways in which employers can use these tools to manage workplaces once people are in the job. That things like oversight and discipline and even termination can be automated in some workplaces. And these also raise considerable risks, not only of bias, but also of really harming workers by affecting their working conditions. They can be used to degrade working conditions, make the work more onerous, make the hours more onerous, make work more dangerous because of pressure to produce very quickly. And it's very often the marginalized communities, workers from marginalized communities that are most affected by these technologies. Your sort of average lawyer working, in their private office is unlikely to be impacted by these types of technologies. But as the data collection and the AI and the algorithmic management tools ramp up, it's going to affect marginalized workers, not only on the front end in terms of access to jobs, but also in terms of the quality of the jobs that they are able to access.
So the worker on the production line.
Absolutely, yeah.
Ifeoma, would you like to expand upon Pauline's observation? Because you
Sure,
did talk
sure.
about this in the book.
Yeah, so thank you for bringing up this issue, right? In the workplace, it's obviously hiring is just a start, right, of actually becoming an employee or worker, and the use of algorithmic management is something that is becoming prevalent in so many different industries, and what we mean by that is that these AI, enhanced technological tools are being used to manage workers in so many different ways. So some of it is monitoring, right? Productivity apps that are actually quantifying very minutely what the worker is doing. Some of it is more sort of surveillance, you might say, that's actually surveilling the worker for any kind of misconduct. This includes apps. I call them bossware, not me, but that's the name that they have become known by. And they really took root during the pandemic because they can be downloaded on your computer, your phone, and they can do things like take a screenshot of your computer every like 2 minutes and send that to your boss just to check that you are actually working. They can actually also turn on your microphone and record what is around you, including if there are other voices. So this is something that, for example, has been used to penalize, right? It's been used to penalize people that have children because if, it does record that there is a child around, some bosses have said, well, you weren't working, you were engaged in childcare, so you are not going to get paid for that time. So these types of AI enhanced technologies are becoming quite prevalent, but there's not really the regulation in terms of how bosses may use them. And there is sort of like a sense of entitlement on the side of employers to really exert the most control over the employees with these technologies.
And the amount of stress that produces
Right.
on the worker
Right.
is
Right.
huge.
Right.
I have a family member who engages in low-wage work, working from home.
Right.
And he told me about the camera in the
Right.
computer or the technology that monitors when you're typing.
Keystrokes.
Your
Yeah.
keystrokes.
Yeah. Exactly.
But Trina, if I could just build on something you said earlier, the notion of how certain jobs are posted and words that are used in interviews, like executed and captured, I think that's just an exceptional point. I'm hoping on the positive side of that we can take AI and even look at the way we advertise jobs. Are there certain words or there's language that, when we look at the results of the applicants we get, are we seeing that certain language is demotivating certain people from applying for those jobs and learning from that process, and then helping to turn that into something that can be positive that we can then say we need to change in terms of how we advertise for this job. So I think there's a lot to learn in this space as we look at these tools, but also asking those questions to say, how do we use this technology to learn what our experience is and then turn that into something that can be beneficial.
If I can just follow up on that, I love this point, and I think there are actually some vendors in this space that are trying to help employers sort of de-bias their sort of job postings and so on. But the really interesting thing about that, the move, right, is what Ifeoma and I were talking about is AI that's directed at the worker, right, at studying the worker, predicting the worker. And this kind of use is actually turning AI on the employer to focus on the employer's processes and the employer's communication, which I think is, sometimes in the employment space, we sort of forget and sort of think, well, AI and labor is all about studying the worker. If AI is also about studying the work processes, I think we can learn a lot of things and have some really positive uses. So, I'm sorry.
That's a hugely important point.
Yeah.
I'm wondering if we might shift to examining the regulatory framework if we're concerned about bias, right, and surveillance. The EEOC has had a number of, has issued some guidance and a number of workplace videos that are available to both scholars as well as employers and the public. And I'm wondering, Ifeoma, if we might talk about the way in which the EEOC is approaching the question of bias and surveillance and privacy, and whether that approach is even adequate, right, for this technology.
Right. So, the EEOC is the Equal Employment Opportunity Commission, right? And it is the governmental agency that is charged with enforcing Title VII of the Civil Rights Act, which is the law that, mandates that there should be no discrimination on the basis of protected categories when it comes to employment. That being said, right, the focus of the EEOC is on discrimination, right, is on bias. So I would say that the EEOC's approach has been to focus on, is there bias? Is there potential for bias? It hasn't been so much to focus on issues of privacy for workers, because, frankly, that's not their charge. Although you could see, obviously, how issues of privacy overlap with issues of discrimination, because obviously things that you might want to keep private may be things that could then be used to discriminate against you as a candidate or as an employee. But yes, the EEOC's charge is discrimination. So thus far, the guidance has been, yes, companies can use automated tools for hiring, but companies do have to be mindful that if those tools, have a disparate impact, basically, if those tools are so biased, right, that certain groups are more disadvantaged than other groups, then that is something that will be actionable. That is something that the EEOC, will intervene in. So that has been their main guidance, right?
A disparate impact
approach, right, to the use of these automated tools. So they haven't necessarily done like a full scale, we will ban these types of school tools, or we are promoting these types of tools, because, there's a wide variety of automated hiring systems out there with several claims. I should mention that in addition to the EEOC, the FTC has actually taken up the mantle on, regulating automated hiring, automated systems in general, but also automated hiring systems. And, obviously the FTC, that's the Federal Trade Commission, they are charged with, prohibiting unfair or deceptive trade practices. So this goes to the claims that some of these AI hiring tools are making. So when the first AI hiring tools were coming out, a lot of them were claiming to be bias-free, right? A lot of them were claiming that they could eliminate the human bias entirely from the hiring process. Of course, this turned out not to be true, right? So obviously the FTC would have the charge to regulate that, to engage with that, because they do regulate unfair and deceptive practices. As a last comment, I do want to note that there is an issue of whether any agency is actually equipped to really regulate automated tools in general. And, that includes the EEOC as well. And this is particularly true now since the demise of the Chevron deference rule. So, Chevron deference was the idea, the legal doctrine that, the courts would defer to agencies when it comes to making rules and regulations on things that are within the agency's purview, right? So now with the end of, and purview was sort of like kind of left a little bit nebulous. It was kind of left to the agency, right, to interpret what would be within their purview. But now with, Loper Bright case, it's a recent Supreme Court case, Chevron deference is essentially done. And it's now saying that agencies would only have purview with things that have been explicitly noted as being within their purview in the, as part of the act creating that agency, right? So I do think that would further limit the agency's power and authority to make rules, the existing agency's powers and authority to make rules regulating AI technologies, because AI technologies are new, right? They were not contemplated when those agencies were being promulgated. So that, I think, can limit their power to some extent.
I'd like to spend a bit more time in this space when we're talking about the regulatory framework, because you mentioned the FTC that focuses on trade, right? And unfair and deceptive practices. And then you have the EEOC, which focuses on discrimination on the basis of protected classifications, race, color, religion, sex, and national origin, right? And the EEOC using this disparate impact approach as opposed to utilizing the disparate treatment framework as well. So you have these two different entities that are operating in this space, but there's no comprehensive sort of governmental approach. So things may fall through the cracks. Certainly you could have privacy concerns and surveillance concerns that will disparately impact, let's say, women or people of color, but is that frame adequate? And so I'd like to come to you, Pauline, and get your thoughts on the adequacy of the regulatory framework and the approaches that are being utilized by these regulatory entities.
Yeah, I'm scribbling notes here frantically because there's so much to say here, although I just completely agree with the bottom line that our existing regulatory structure is not adequate to address these problems for all kinds of reasons. So the EEOC has the tools that it has. The disparate impact doctrine is the strongest tool that it has, so that it can examine employers if they are using a tool that is disparately affecting a disadvantaged group, disproportionately screening out disadvantaged groups from the workplace. But that tool, looking at disparate impact, looking at its effects, while it's very important, doesn't really give them much power to deal with the front end, right? And this is what Yifan was talking about with all the data collection that goes in to feed these things. The FTC has sort of tried to step into this space, but the FTC is a little bit, and they've done a lot in the privacy area. And again, with the tools that they have, I'm going to not even talk about Loper Bright because that's a whole nother level. But with the tools they have, FTC has tried to step into this space. But there are two significant limitations I see in the employment context. One is the FTC's mandate is framed in terms of consumers, not workers, and they are trying to kind of push on that. But workers are different from consumers. They are situated differently. And even aside from the textual authority, there's the question of whether they face the same types of problems that consumers do. And that goes to the second point. FTC is about fair and deceptive practices. And in the employment context, the easiest thing for an employer to do is just to say, we're going to collect all this data about you. Part of signing up for this job is agreeing that we can collect all this data from you. And it's not deceptive anymore. And whether it's unfair is a real, there's not a lot, I mean, there's an argument that can be made, but that would be a real, it would require a lot of innovation, let's say, on the part of the FTC to get there. In addition, a lot of the other sort of challenges that we were talking about in the workplace, we have other agencies like the Department of Labor, right? Department of Justice that have sort of some areas of oversight over employment, but they tend to have very kind of specific charges. And so the thing that is missing in the workplace is an agency or an entity or a law that is dealing sort of holistically with the issues that are arising out of the use of data and the collection of data about workers. So I think that there is definitely a need for more coordinated response to these kinds of challenges in the workplace. I don't know if you want me to talk about if I should go into sort of what I also see as the legal challenges to even dealing with this. So I don't know.
Yes.
Okay.
I'm thinking about disparate impact theory. I'm thinking about the Ricci case.
Yeah,
The
okay,
fact that
all right.
disparate
The
impact theory
limitations,
is
Yeah.
limited, right? And under attack, right?
Okay.
It doesn't
Right,
work in the equal
I
protection
didn't know if you wanted me to go there yet, but yeah, so I was gonna say that so with this sort of regulatory gap, I think one of the most important things is to have employers who care about the issue and want to use AI in equality promoting ways and not equality reducing ways, that internal effort on part of the employers is going to be very, very important because we don't have a vigorous regulatory structure right now. And that has raised this question of, well, when employers do that, that requires that they be very conscious of the race and gender outcomes of these tools. And some people have started to say, well, if an employer examines one of these tools, finds that there's a racial impact, and then starts messing around with the tool to reduce that racial impact, is that in and of itself a form of discrimination?
And that sounds exactly like the Ricci case.
That is the Ricci
right?
case,
right.
So that was a case that was decided more than 10 years ago, involved this New Haven Fire Department, which administered a promotional test for lieutenant and captain positions. And when the test results came back, they realized the test would have a significant racial impact, that at least with the first tranche of promotions, they would almost overwhelmingly go to white firefighters, even though the pool of firefighters that had taken the test was quite diverse. The city was concerned about a disparate impact lawsuit. And so they, after multiple hearings and hearing from experts, they decided to throw out the test, and they were going to devise a new test that would have less racial impact and use it for promotions. And they got sued by a group of white firefighters. And the US Supreme Court said that what the city of New Haven did was a form of race discrimination that they could not justify merely because they were afraid they might be sued for disparate impact. So this has raised a lot of concerns about why, whether there's a problem with examining practices that have a disparate impact and trying to remove them. I think that there's a lot of really bad rhetoric in the Ricci case, but that it is really important not to overread the Ricci case. I think the best way to understand the Ricci case is in that particular situation, you had an employer that had announced a policy, had announced this examination, had provided study materials, and that there were a group of firefighters that in reliance on that had studied, had spent money, had spent time, and that what the Supreme Court was doing was saying that once they had made that commitment that this was how they were going to hire and there was that investment, the Supreme Court became very concerned with protecting the reliance interest of those individuals. I don't think it applies in a situation like this, where an employer realizes there's a problem with a tool or an AI tool that they're using and says, this is a problem, we're going to stop using it and we're going to fix it going forward. There's nothing in that case or in any of the Supreme Court cases that have been decided recently that would prevent an employer from doing that. Unfortunately, I think there's a lot of rhetoric now coming out on the right that is trying to suggest that even trying to get rid of disparate impact is somehow a violation of the law, and I think it's really important to be pushing back on that story. Yeah.
Excellent.
From an employer standpoint.
I was about to segue
Yeah,
to
sorry,
you
go ahead.
for the answer about how we can promote equality promoting employment practices, since you're here representing employers.
Yeah,
to some extent.
the fact that this is such a quickly evolving arena, I think it makes it extremely difficult for employers, right? So Whereas some of these tools are touting that they can help reduce bias, maybe not eliminate it, but help reduce it. But because the EEOC is responsible for, making assessments based on disparate impact, discriminatory practices, they would hold the employer accountable for any employment decisions that reflected that, right? But if an employer said, okay, we want to bring in this enterprise system to help us be more efficient and hopefully reduce our bias, and then there was something in the algorithm or the data set that did not do what it said it was going to do, and the employment decision came out and was discriminatory, then the employer is accountable, is my understanding, is the employer. So I think, while there is a lot of potential for these systems to actually reduce human bias, which we know exists, I think employers are very cautious about approaching these decisions and making a significant financial investment, knowing that if you accidentally, because most employers, I don't know algorithms and data sets, and so as a human resources professional, I can't look and say, okay, I feel comfortable with this. There's a certain reliance on the expertise of the companies that are building these systems. And if it comes to find out that we've made an employment decision using those tools that actually negatively affect or increase hurdles for our marginalized people, then we've made something that we're liable for at that point. And not only just liable, those decisions happen individually, but the liability is isolated usually to that hiring manager and that hiring decision. You bake it into a system in your recruiting process, the potential is wide scale. So I think that has a lot of employers that are approaching this with tools that could be really beneficial with a lot of caution.
Is that caution good?
I think the caution is good, absolutely. How do we get to, because the EEOC they don't know algorithms and data sets either, so they're only looking at the outcome of the decision. So there's a gap in here somewhere to say how do we get to some whether it's regulatory environment that steps into, whether it's the FTC or someone else, to help say this system is reliable and we can depend on it. The potential again to reduce the bias is significant, but I think the quickness with which people adopt and companies adopt these systems are going to be slower just because of the potential liabilities.
Yeah, I think, what you describe is a true dilemma, right, for employers who want to do the right thing, right? They want to have, a diverse workplace. They want to be in compliance with the law. And they also want to have these efficiencies of scale with these technologies, but they are afraid, right? They're worried about the liability of adopting these technologies that may then have an unintended disparate impact. So I address this in my book. I talk about what can be done, right, to ensure that these technologies are actually working as they claim to work. So one thing I am in sort of favor of is regulations mandating audits of these technologies, right? So some of legal scholars have asked for certifying systems, right? So I think Andrew Selfs and others have written about that, saying that before these systems are even launched in the marketplace for employers to have access to, they actually need to go through a certifying system that's saying, okay, they've actually undergone some tests to check that they have, the systems that they claim that they do, and that they are not replicating bias or have baked-in bias. I go further. I actually say, even after these systems are launched, there needs to be auditing systems in place to check them for bias. And I actually say that, and I think Pauline has also written about this, there could be some sort of safe harbor, right, for employers who do actually engage in the auditing and they find bias and they attempt to fix it. Like there should be a safe harbor for that, because obviously at that stage, there's not intentional, discrimination happening. So I do take to heart what you're saying, and I think the issue there is a lack of regulation on the part of the government. So the government could, through the EEOC, for example, mandate audits of these systems. And there's, various ways to accomplish it, right? It could be the EEOC, develops an arm that's doing these audits. There are also third-party auditors that have already arisen. There's ORCA, which is housed, I think, in Boston with Kathy O'Neill. So there are already third-party auditors in existence, but it's just that there's no law saying that this has to happen.
I think if I can just jump in here, one of the challenges, again, the agencies work with the tools that they have, and the EEOC has the tools to go after employers and not go after vendors, right? And so I'm guessing they would like to go after the vendors if they could, or to have some way of imposing accountability on the vendors, but it's a difficult sort of legal needle to thread. Right. I think it's actually an open issue of whether the extent to which the employer would face liability if they're entirely relying on an outside vendor and then were auditing and then found out, right, and stopped doing it. But no employer wants to be the one to be the test case for that, right? One of the things that I have heard, and I'm a little bit curious, is that some employers try to deal with this through contracting with the vendor for indemnification, and whether, as an employer, that feels like a route, or it's just not reliable enough to, you're still worried about being the test case.
Well, I think that's certainly a step in the right direction, right? I think that is another option, especially without the regulatory structure and reliance there. But I'm headed to a conference next week, and AI is probably 50% of the agenda for the conference. And I'm curious, there'll be vendors down there. I want to have these conversations because, again, the environment is moving so quickly. It's just the technology is moving faster than the regulatory and legal framework.
Yeah, for sure.
And I have to say that, the employers that I worry about the most are not the employers who are being very thoughtful and very careful about it, but the smaller employers who are buying sort of off-the-shelf products from vendors and asking very, very good questions. And that's really, I think, where the risk comes in.
And when I think about, like, how do we help protect, how do we help put safeguards in place, my first answer to that has nothing to do with technology. It's all about your core values, right? And so,
and that takes us to the final question, right? Before we open this for Q&A, and that is, how much can law and regulation do in this area? And I'm going to start with an observation from the quantified worker and end with a question that I think takes us to where you are now, Paul. So this is Ifoma's words. It's often overlooked that technology and ideology are co-constitutive. In other words, technology only exists insofar as it's conceived as part of an ideology and is used in service of that ideology. Thus, technology is never neutral. Embedded in both its design and use, cases or theories of what is and what ought to be. And then you go on later to point out work technologies of today come imprinted with ideologies about worker power or the lack thereof. Today's work technologies reinforce attitudes and beliefs about how far the employer is entitled to seek control over workers. In short, these are my words, the problem may not be the technology, the problem may be us. Right? And so how do we look at that, at what's happening outside of the regulatory framework, beyond the law, and establish some controls?
Right. I'll jump in there. First, I want to shout out Charlton, right, who wrote, some of the earliest scholarship on, technology and its, how ideology definitely is embedded in technology and its uses. So definitely shout out to him. He charted this path for all of us. For me, when it comes to specifically workers, and the technologies being used to manage workers. As I note in the book, it's really all about how the law and also societally we think about work and workers, right? So in American law, there is this huge legal deference to employers. The worker is seen as just not as important as the employer, right? And it's seen as like, when the worker accepts employment, the worker is expected to essentially kind of give up privacy as part of that legal bargain. And so there are these ideologies of that the worker, even think about employment law. You have the master servant, right? Sort of relationship that's noted in employment law. And that is how workers are still seen as sort of like beholden to the employer. And this, of course, dictates how they will then be treated by the law, right? And what sort of protections could exist for protecting their privacy, protecting psychological issues that might arise from over surveillance and things like that. So there is this ideology that you want employment, tough, give up what you need to give up to get it. And there's not necessarily an emphasis on like human rights, human dignity, even as a worker.
Thank you. Paul, you wanted to talk about values.
Yeah, I was, going to say that the values of your organization. So higher education's again slightly different than many employers, right? We have maybe
Still?
but our core values are inclusion, respect, trust, excellence, and diversity. And the first step is putting that at the center of your employment-related decisions, including about use of AI, right? So when you look at AI, you're looking at two pieces, at least from an employment perspective. One is, proper design. Is it configured in a way with the data sets and algorithms that is going to do what you want it to do, which is hopefully reduce bias and create efficiencies in that process. The second one is around proper use. And so again, you have end users who are involved who also have some ability to influence. And that is where we're doing some of that work now. We're offering training, and we're looking at creating governance structures. How do we use our data internally and through systems with artificial intelligence? That's a big piece because ultimately the users are the ones who are going to be executing on many of these things, employment decisions, whether it's, whether we use it for recruiting, performance management, termination processes that crosses the entire spectrum of the employment cycle. And so for us, I think, where you start from, if our values were we have to be first to market, we have to be faster than anybody else, well then you're making some assumptions about risk. You're willing to accept a certain amount of risk to be first. That's not our value set, and that's not kind of our ideal. So we're going to take longer. We're going to ask a lot more questions in looking at these systems to make sure that we have some comfort with that this technology is actually doing what will make us a better and more inclusive workplace.
Thank you. Before I open the floor to questions, is there anything you'd like to say that we haven't covered? And I know we started our conversation, which you didn't hear, picking up on the last panel and talking about some thoughts that we had about that discussion. So let me just give you an opportunity to say what you feel needs to be said before we go to Q&A.
I was just going to make a connection to the last panel based on, because I think I agree with both Ifeoma and Paul said here that it really matters what the values are that we bring. Technology is not a neutral thing. It matters the values we bring to it. And I thought of, there's a really good example from the last panel, and we look at what's happening in Hollywood and the growth of these Gen AI tools, right? They can be used to enhance the creativity of creators, or they can be used to replace individual creators. And I think that kind of a question can be asked every time we're implementing AI, like what's the underlying value, whose interests are being served, who's at the table who gets to define what the problem is and how we're going to try to solve it. And so I think that it is really important to be aware of those choices, but also when we talk about inclusion, that means inclusion in the voices who are deciding how the technology is going to be deployed. So.
Thank you. Paul, you go on?
No, I just think it's a fine point. This is an evolving space, and again, we will all be looking for ways, but I think what you bring to the technology is as important as what you take from the technology.
Thank you.
I'll see to the audience, and I want to hear from y'all.
Questions? Brandon?
I'd love to hear your thoughts on how the considerations might be different when it's a government employee and other rights would attach.
Pauline, might we start with you, because I think you've written about the public context, right?
Yeah.
And affirmative action and ways in which the deliberate use of race, right, to try to prevent bias, may be viewed by some as being a form of racism, and I think you push back against that.
Yeah, so we had the conversation about Ricci, and I think we could have the same conversation about the constitutional question, which I actually think comes out the same way. I don't think anything, and if anyone wants to go into the weeds about this, I'm happy to do it, but I don't think SFA actually really changes that. I think that even under the current court, at least if they stick with doctrine as they have articulated it up until this point in time, right, which is maybe a caveat, right, that public employers, like private employers, have room to investigate their own practices. And actually, not only can, they should be investigating their own practices to determine if there's a disparate impact and to try to remedy that. And there is nothing in the Constitution or statutory law that prevents them from doing that. And the people who are arguing otherwise, I think that's a misreading. In many other ways, so in some ways, I think public employers are like private employers in terms of the interests of the employees. They are employees, they're subject to the authority of the employer. So many of the things that we talked about, I think, would be the same. I think that maybe one other consideration that might be a little bit different is the public service nature of the enterprise. And that may come into play in terms of thinking a little bit differently about how AI is used in the role of workers in AI. Because as AI becomes incorporated into the workplace and how workers perform their tasks, they're not only subject to the AI, but they're also using AI. And when AI is being used to make decisions about things like public benefits, in the criminal context, which I won't touch because there are lots of experts in the room here, right? There's a whole nother considerations that come in, set of considerations that come into play. But that's kind of on the side of like how workers use the tools and the technology and what kind of voice they should or shouldn't have and how they're deployed. I hope that's responsive to.
And and to add to that, I do want to note that one other striking difference between private and public employees is the Fourth Amendment, right? Which does dictate what sort of privacy they get. So, as a public employee, you are subject to the Fourth Amendment because like the person that would be surveilling you would be the government. But as a private employee, there is none of, you don't have that protection. So I think that would of course, have an impact on what sort of like surveillance AI tools governmental employers would feel comfortable using in terms of like how pervasive and invasive they can be. Whereas, private employers don't have that check. They really don't have that check on them. So I do think that's a key difference.
Thank you. Yakut, it's good to see you here with us. Yakut Ghazi, if you don't mind my introducing you briefly, and I'm probably going to just butcher your title, but is the Vice Provost at Duke for Learning Innovation and has been doing a lot of work in this space, so thank you for joining us.
And a portion of my oversight is on lifelong learning and lifelong education, so I'm keenly interested in the workforce development aspect of the conversation. And I'm going to ask a question that may sound politically charged, but it is really coming from a place of deep curiosity and desire to understand. Let me talk about the differential impact on the workforce for AI and job losses. To what extent do you hear the conversation around universal basic income? And then what are your thoughts, if you would like to share with us?
This is a weighty topic. I don't know if we agree or not. I'm not sure.
I don't know that we've ever had.
Right, I don't think we've ever talked about
Let's see what happens.
Yeah, universal basic income is something I touch on briefly in the book, but I've actually talked more about it in a forthcoming article, titled AI and Captured Capital. So, thinking about the fact that as part of the AI revolution, workers are oftentimes unwittingly fodder, right? They are producing the data that's actually being used to train these AI systems. And they're producing it without necessarily having any recompenses. I'm saying that wrong. They're producing it without having any compensation specifically for that data, right? So, for example, as consumer, you're also producing data, but in some ways, it could be argued that you're getting the benefit of that data that you're producing because it's being used to optimize, the stuff that's being then sold back to you. But as employee or worker, that's not necessarily the case, right? And in fact, the data can then actually be used to displace you entirely as a worker. But where is your compensation? So one of the arguments I make is that this actually is really, really making the case for a universal basic income, because we can't assume that all workers will be able to reskill, upskill, and then just find another job elsewhere. We do have to sort of like come to terms with the fact that there might be workers who are just permanently displaced, and we need to know what to do with them, like what to do for them, not with them, but for them, right? And so universal basic income could be a way to handle that. Now, I recognize some of the limitations of that. Some legal scholars, Brish and Rogers, for example, have pointed out that, whenever you have governmental programs that are benefits or, seen as sort of like some sort of grant from the government, there's always limitations put on them, right? Like if you think about public housing and things like that, one of the limitations of public housing was you can't be a felon and live in public housing, but that then actually had a disproportionate effect on people of color who were more often caught up in the dragnet of the war on drugs, and therefore could then not have access to public housing. So his concern is that a program like a universal basic income might also have limitations that then have disproportionate effects. And he's right. I certainly agree with that. But I'm saying we can, preview that, right, and put things in place for that, to make sure that that doesn't happen, right? It doesn't mean we should then abandon the idea of a universal basic income. And there's, I think, various ways of thinking about how to do it. Some states are actually doing pilots already on, they're not calling it universal basic income, they're calling it guaranteed income programs. So these residents of the state are getting a certain amount per month to live on. If you think about it, the stimulus during the pandemic is a type of guaranteed income, right? People got a certain amount of money per month. And there's several studies ongoing about the effects of that, where there how shall I say, misappropriation of those funds? Of course there were. And people also have concerns that that might happen also with a universal basic income.
Okay. Pauline?
Go ahead.
I don't have, private employers aren't really engaged in that discussion as much. And so it's not been a topic that we've really engaged in.
So I have a kind of complicated answer to that. And maybe you could just say it's a wishy-washy answer to it. Because I want to think about these things separately, right? I think there are good arguments that as a society we should provide a minimum floor that allows everybody to flourish, period, right? And when I think about the workplace, I think the society we should be working towards is one in which everybody who is capable and interested in working can get good jobs that are economically rewarding, meaningful, respect their dignity, and so on. So I think both of those things are really important. I think one of the ways that we move towards, or at least not further away from, the world that we want in work, given the changes in technology, is that we need to be very intentional about how technology is being deployed. And this goes back to like, whose problem are we solving, who's at the table when we make those decisions. So, and we get away from the idea that, I think this part of the narrative that like, technology is proceeding, there's nothing we can do about it, workers are going to be displaced, like that's really too bad, but we can't do anything about it. I don't think that's true. I think that we make choices as companies and as a society about how to deploy technology. So to use as an example, in Germany, there is a collective voice for labor that is much more involved in decisions about how technology will be deployed at the front end. And so what that means is technologies have been deployed in more productivity enhancing ways in Germany and less on things like surveillance and control of labor like they are in the US. So there are choices there. And so I would like to see a world where the way in which we govern AI brings worker voice to the table so that we are working towards that sort of more ideal picture of work that I said at the outset. Now, I can't separate these because they're part of the same conversation, right? But what troubles me when they're part of the same conversation is that a lot of the rhetoric around UBI is coming from technologists who are saying this is inevitable, right? Technology is going to be developed. We're really sorry workers are going to lose their jobs, so let's just get UBI, right? So that it's a way of kind of justifying this inevitability of the technology. And that's where I want to push back and say, why are you motivated to talk about UBI, right? Like, what's the motivation behind that? And I'm honestly a little cynical about when some of the UBI, the push for UBI comes out of Silicon Valley. So that's one piece of it. Even aside from that, this goes back to points that Ifeoma was making. And again, as I said at the beginning, like I would prefer to live in a society where people have the basic sustenance they need for a flourishing life, right? We have not been able to do that as a society. And as a matter of sort of political reality, I'm not sure that we are going to be able to do that, even in this sort of new technological world, right? So I am worried about relying on UBI as a solution rather than trying to solve the problem of creating good jobs for everyone, meaningful work for everyone. And that the discussion about UBA may be a distraction from that other discussion about how technology is used in the workplace.
I'm going to exercise moderator's privilege and just ask a question based on what I'm hearing. So you mentioned Germany. You talked about good jobs, right? We've been focused on the domestic context and not the international context. When we had our program a year ago, and I think Sonia's left the room, I think she made the point that in the development of the technology, you have to teach the technology, and you need to teach the technology to screen out certain types of biases, and that it's workers, international workers, who are being used to teach the technology how to identify harmful material and filter out harmful material. What about the impacts of that on those workers, right?
So yeah, I'm happy.
Protections for them.
Yeah, I'm happy to touch on this because that's a big part of the article that I have, forthcoming. So, recently there was this big expose that, companies like OpenAI and other AI developers were actually using workers in the global south, specifically Africa, Kenyan workers, to moderate content. And these workers were being paid like $2 an hour to moderate content that like bestiality, sexual abuse, all these sorts of things, content that was very psychologically harmful. And they were not provided any like sort of counseling or, benefits to help alleviate, this really difficult work that they were doing. And this was work that was very necessary to creating ChatGPT and other AI technologies. And also, and the investigation focused on OpenAI, but it's been found that it's not actually just OpenAI doing this. It's several companies, several Silicon Valley companies are basically contracting these third-party companies who then hire these African workers. So they're even maintaining this level of separation where these workers are not employers, employees, definitely. And there is this issue of the lack of extraterritoriality of labor law, right? We have labor laws in the US that offer protections for workers in terms of the kind of work that they can do, the sort of benefits or support that they would require, even sets like minimum wage floors, things like that. Those laws do not apply overseas. Even when our American companies are operating overseas, they were not subject to those labor laws. And so there is a question of is the AI revolution really going to be happening off of the backs, right, off of the exploited labor of people in the global south? So is AI revolution really going to mimic what we saw with colonialism and other extractive industries, like say the oil industries, where it's going to be about extracting resources from these workers in the global south without adequate compensation? So my paper is exploring how do we deal with this, given that American law has not provided for this. So I say that there is actually a role for intergovernmental agencies like the ILO, which is an international labor organization connected to the UN, to step in here. And first of all, set minimum wage rules for these different countries. I mean, obviously, it is going to be a huge task because there are several countries involved, but it's not an impossible task. You can, do studies in each of those countries to figure out what's an appropriate minimum wage there, and then make it binding on the member states to the ILO that, they would then hold the companies incorporated in those states accountable and responsible for actually paying adequate wages and providing, adequate support for the workers. But yes, it is a problem because, the AI development is not coming out of the vacuum. It is human workers, really, that are the backbone.
Thank you. Margaret?
I have a question for all of you. So, Ifioma, one for each actually. Ifioma, so really appreciated your comment about Chevron doctrine and the rollback of labor. And I was wondering whether or not you thought that the solution would be more explicit, directed in future statutes that are being proposed for AI oversight and regulation.
Right.
Or do you think that the agencies who are trying to regulate these systems need to rely on and double down on the fact that they do have the authority and to read the existing statutes more liberally and make that argument? And then Paul, we talked about the need possibly for more sophisticated technological training in HR programs, and would love your insight on how we would do that. And then Pauline, for the U.S. Department of Labor, the Office of Federal Contract and Compliance Programs, they do have a role in the procurement oversight and trying to prevent discriminatory contractors and vendors that the government brings into their programs. And I know that some of the conversations have been whether or not OFCCP should have a certification program for the safety of certain AI systems, and they have resisted that role. And we had talked about, we heard your thoughts about auditing and assessments, but do you think the federal government needs to step in and take a more active role in that? So would love to open that up.
Okay. Yeah, regarding the Chevron question, right, or the demise of the Chevron deference, I don't think it has to be either or in terms of your question. I do actually think both can happen with several caveats, right? So yes, I absolutely agree that we need more targeted, explicit regulation that is granting power, to either existing agencies or the creation of a new agency in terms of tackling AI regulatory issues, right? I do think that's absolutely necessary. That being said, I don't think it means that, that the end of Chevron deference means that existing agencies are completely toothless with regard to actually regulating AI. I do think they have to tread carefully because they can't do things that are like far removed from their expertise. Like the FTC, for example, can't now start focusing on workers when that's not their specific gambit, but they can still focus on unfair and deceptive practices in terms of how the vendors, right, are selling this automated hiring tools. That is still within their gambit, right? So I think both can happen at the same time, and it doesn't have to be either or.
And in terms of the training question, thanks, Margaret. In thinking of this, I think about it again at the end user perspective as well as kind of the enterprise perspective. And so there is current work now. The Office of Information Technology here at Duke is offering a series around artificial intelligence and helping our community understand what it is and how it works. And so, for instance, there's a lot of talk about Chat GPT, right? So people are going out there and trying this tool out. We want to be careful about that from an institutional perspective because what goes into Chat GPT becomes kind of part of that public domain. We have an agreement now with Microsoft where Copilot, is institutional. That's closed system, so you can use that system when you sign in with your Duke account and know that you can do some of the same types of things, but you're not sharing that information with the world. And so there's some privacy issues there that we're trying to help educate our community around, when and how to use these tools at the local level. When you think about the enterprise level, if we do adopt, and I presume at some point we will, AI for some of our enterprise systems that deal with applicant tracking, then we will definitely have to rely on the vendors in that space to help educate the recruiters and others who are using these tools to make sure that we're using them in the appropriate ways. So again, I think some of this is we're taking efforts now proactively, but within a space where there's not a lot of external guardrails. And so as those come into existence, as new laws, as new policies get developed, just like with the Office of Institutional Equity, when we think about harassment and discrimination, then we require like regular training of all faculty and staff to participate in something like that. We don't have that hard backstop to kind of develop something that helps us kind of require and mandate that.
Thank you.
Yeah, so certification of AI systems. I guess I'm going to hedge a little bit because I think a lot of it depends. And certainly I guess I'll stay in the employment context, right? When we have these vendors that are offering these tools, it's a little bit of a double-edged sword because on the one hand, a certification system would be good in the sense that it could give vendors incentives to meet certain standards. Like there's just stuff you shouldn't be doing, right? That is just, not best practices, really likely to cause bias. And it would be good to have sort of clear standards that would incentivize the vendors to comply with those basics, right? But the flip side, and the thing that I'm worried about, is that would this then become a shield, right? Where they say, well, we met your certification, we're done, clean bill of health. And we all know that AI systems, their effects can differ depending on the context in which they are applied. And a system that is not biased one day, 2 or 3 years down the road, can be biased because the data on which it's trained is no longer representative of the world in which it's trying to make predictions. And so the risk with certification is that people will say, it's certified, it's done, you know, I don't have to worry about it anymore, as opposed to doing the kind of ongoing scrutiny and auditing to make sure that the systems are still good. So yes, maybe. It's something to look into, but with a lot of caution in terms of the uncertainties about, you know, how the world changes and therefore the technology changes going forward.
Any final questions? I have a lot, but I think that I'll break here and join me in thanking this panel. Yvonne, Paul, and